you. Thank you, Adam. Thank you all for staying. Affordable Care Act. Anyone heard of that familiar? No? It's new to you. Okay, good. So it's like, getting to be my age. You're always meeting new friends. I always like to start with a picture of myself so that you think, who was that guy? And I always like it if I can show a picture of my best side so that you think, oh, yeah, now I remember who he was. He was the guy who was looking out the window while he was talking to me. And I also, of course, like to include a picture of you so that you know what it feels like for me to be up here looking out. I know it's been a long morning. You're tired. The coffee on your table may already have got cold. I hope not. But I still think of you as wise old owls, as you'll see when we go through. So Mike McClory said, and of course Adam said we won't have time to take questions. I'm sorry about that. But Mike McClory said he would take questions. So if you have questions about the Affordable Care Act, I encourage you to call Mike McClory. In fact, if he's still here, you can go bother him right now while I'm talking. We're going to talk about two different player pay reporting requirements. So player pay, sometimes called the individual mandate. Individuals have to have minimum essential coverage or they're subject to what are still relatively minor penalties. That's governed by Section 6055 of the Internal Revenue Code. And then the employer shared responsibility requirements, where applicable large employers, we'll talk about them soon, are subject to penalties if they don't offer minimum essential coverage, actually if they don't offer affordable minimum value coverage to essentially all of their full-time employees. Talk about all of those concepts. We're going to look at different categories of employers, because I'm guessing, notwithstanding the fact there's some private sector, mostly public sector employers, that many of you fall into different categories in terms of size and also in terms of where your employees get their health coverage, whether they get them from your plan or from a multi-employer plan, whether it's a fully insured plan or a self-insured plan. I'm afraid I'm going to forget that there are two different sets of forms, and they're governed by not the number but by the letter. So there are the B forms, 1094B and 1095B, and those generally apply to not large employers, the employers who are not applicable large employers. Then there are the C forms. So if I get lost somewhere between the 1094 and 1095, the key distinction is the B forms for the smaller employers and the C forms for the larger employers. Okay? So we might as well get going. Now, I would normally show you pictures of cats, but Dan Rowan showed you pictures of cats. It just can't be done. It would be doubling up, and it might bore you, actually, and I'm good enough at that without the cats. Let's look first at the 6055 reporting. Now, maybe what you've thought when you thought about the Affordable Care Act and these sort of player pay penalties, the individual mandate and the shared responsibility penalties for employers, maybe you've thought is, how are they going to catch me? No, you probably didn't think that. You're mostly public employers and public-spirited. But I thought that. I thought, how are they going to catch this for anyone? And the answer is with these rules we're going to talk about today. The reporting that's going to be required of employers so that the regulators can catch the people who either don't have coverage and should have it, subject to the individual mandate, or don't have coverage and should have it, and the employer might be subject to that shared responsibility penalty. So the 6055 reporting is the reporting that's used to catch the individuals, and it's fairly simple. So you can see I've posited four kinds of employers here: the fully insured, not large employers, the self-insured, not large employers, and the fully insured and self-insured applicable large employers. And they're basically subject to an increasing range of regulation, increasing level of responsibility. Now, if you're an employer and let's say you're a not large employer, you have a fully insured plan, and so you're up at that top level, you're thinking, I have the smallest level of responsibility, the smallest number of obligations, that's great. And if you were also thinking, but I have this self-insured HRA, health reimbursement arrangement, that I offer to my employees. I put a little bit of money into it each month, each quarter, each year, whatever it is, and the employees can spend it on deductibles, co-pays, or uncovered medical services. That doesn't make you self-insured. The regs that the IRS issued very recently said, no, you can just look at that fully insured plan, a supplemental HRA that you offer to supplement your regular medical coverage doesn't turn you into a self-insured employer. And you know our definition of applicable large employer. It's the one that's generally used for the player pay penalties, and that is employers with at least 50 full-time equivalent employees. And you know full-time equivalents is actual full-time employees and then fractional employees based on, for this purpose, a 120-hour-a-month standard, just for determining whether you are or aren't applicable large employers. So let me put you on the spot. Anybody here work for a company that is not an applicable large employer, fewer than 50 full-time equivalent employees? Great. So the good news is you're going to go home happy. The bad news is everyone sitting around you is mad at you right now. They're jealous of you. Okay, so here's the good news. The fully insured, not large employers, you don't have to report under either 6055 or 6056. Still have to put something on the W-2 that we'll come back to later. But you don't have to file either the 1094 or 1095B or the 1094 or 1095C. If you're a fully insured, not large employer, your insurer will handle that. They're required to report. That's the good news. I'm afraid it's downhill from there. How about the self-insured, not large employers? They're subject to a higher level. They're sort of the second level of regulation and obligation. The employer then has to complete, they're just dealing with the B forms, not the C forms, which are more complicated. But under the B forms, they file Form 1094B, fairly simple transmittal identifying themselves, saying what their plan is and how many people they're reporting about. So they're going to attach individual statements for each person covered under their plan. And then they're going to file the 1095B as well, but just those three items, 1, 3, and 4, where they say who are the people covered under our plan, who's the employer that's providing the coverage, and what months did that person and that person's family have coverage. And that's to help the IRS to determine, wait a minute, you're a small employer, you're not subject to the mandate, but you employ Tom, and Tom's not covered. So we don't have any evidence that Tom, on a Form 1095B, had minimum essential coverage. So unless he had it somewhere else, he might be subject to that penalty. Dollar amount for 2015 is, I think, $325 for the year. So not a lot of money, but that's how they catch Tom as an employee of a small employer. So that the filing, it has to go electronically. You can see if that you have at least 250 forms, that would be a small employer with a heck of a lot of turnover. I hope you don't have that experience. If you file paper forms, the due date is February 29, it's leap year. And if you file electronically, you get an extra month to March 31. That small, that is not large, employer who with a self-insured plan also has to give a copy of that Form 1095B to those employees, basically telling them, this is what I told the IRS about you. If the employee says, fine, send me it by email, you can do that. Otherwise, you give them a paper copy. And that's the first due date. It's basically like your W-2. I think that January 31 of 16 is a weekend. So that's why the due date is February 1. It's not that you get an extra day to do it. It's that the W-2 and the 1095B copy to the employees, not the IRS, is actually due on February 1. Okay. So those are the people who got off either scot-free or kind of easily because they were not large employers. But now for the applicable large employers, it gets harder because we're going to look at the 6066 reporting, or 6056 reporting, I'm sorry. And so I still think you're wise owls, but I'm afraid skeptically wise owls, and rightly so, because here we go. These are the C forms now we're talking about. 1094C is a transmittal, 1095C is the actual reporting forms. And the purpose of these forms is not the individual mandate, it's the employer shared responsibility penalties. This is how they catch large employers and say, wait a minute, you're not providing coverage to enough people, or you're not providing affordable coverage, or for whatever reason, we're going to look more closely at you because we think your people might be entitled to a subsidy if they come to the exchange and buy coverage. And if that happens, you might be subject to a penalty. So here are due dates here, a familiar due date to give copies of Form 1095C to the employees familiar February 1, 2016. The first paper returns due to the IRS, again familiar February 29 of 16. Electronic returns by March 31, same rule. You're required to file electronically if you have to file more than 250 returns. It's not based on the prior year. Obviously, there is no prior year reporting. You're permitted to file for 2014, but not required to do so, and no one did. But for 2015, if you have to file more than 250 returns, why then you have to file electronically. Okay, that's who files and when you file. What do you file? Well, let's look at it. All of the applicable large employers, including those between 50 and 99. I'll come back and talk about those of you between 50 and 99. There's some good news, but it's not a complete exemption. You know that you're not subject to the player pay penalties for 2015 if you're between 50 and 99, but you still have to file. And you have to point out that the reason that you're filing is you're between 50 and 99, and we'll look at that too. So all these applicable large employers complete the 1094C, the transmittal form, basically the cover note to the IRS. And by the way, those forms are in your materials at the very back. So just at the back of tab 5, the first thing you'll see is the IRS 2-page color publication where the IRS explains and says, basically, this is easy. We explained it in 2 pages. And then there are the forms behind it, so you can actually look at the B forms that we've already talked about and the C forms, and they look fairly easy, and they're not. But they look easy, so someone did a good job of making them. So we looked at the transmittal form, the 1094C. Again, we're looking at C forms because we're talking about applicable large employers. Now let's look at the 1095C. So all of the applicable large employers complete Part 1 and 2. If you're self-insured, you'll also complete Part 3, which isn't a whole heck of a lot harder, but it's one additional item to be completed by the self-insured large employers. And we're completing a form for each full-time employee. And it's for each full-time employee that we've had at any time during the year. So if you have a couple hundred employees, you're filling out a couple hundred forms, or someone's doing it on your behalf. We're going to look at that too. What about former employees, people who are on your plan because they're directors, say outside directors, they're former employees, retirees, what have you, people who are getting retiree coverage under the early retiree rules in ORS, or they're COBRA qualified beneficiaries. And you can put those people on these forms as well. You can file the B forms for them, or you can include them on the 1095C. I'm guessing we'll probably put them on the C, that'll be easier to remember to do. Can you have a third party do this for you? The general rule is sure, yeah, absolutely, but you remain responsible for what they do. So you hire a third party, you say, we'll hire Kramer Reporting to do this. Kramer Reporting messes it up. And basically the IRS comes to Kramer Reporting and said, oh yeah, my clients were so-and-so, and they messed up. They trusted us, like they said in the film Animal House. They didn't say messed up, but you know what I meant. The one exception is that second bullet on this slide, and that is that governmental employers can designate one governmental agency and say, you do it for all of us, and then that agency is in fact responsible. So if you're, say, the fire department and the city says, we'll take care of it, and even though the fire department has its own separate payroll and its own collective bargaining unit and its own maybe separate plan that it provides just for the firefighters and doesn't provide to other general service city employees, if the city says we'll do it instead of the fire department doing it, the city is then responsible. It's not like a delegation to a third-party vendor. That's actually permissible. If the city says, fine, but we're going to have payroll service X handle the fire department's reporting, and we, the city, will handle it for everyone else, the general service employees, or something like that. If that's the way it works, you can, in fact, file multiple reports, but the city or someone has to designate one so-called authoritative report. And the authoritative report is the one that says, this is the one that tells you all of the detailed information about the coverage we provide. That last bullet is the nasty surprise. Anybody have coverage, any of their employees covered under, say, multi-employer health plans like the Oregon Teamster Employer Trust? Anybody have that, or covered under any other multi-employer health plan? I'm not seeing hands raised, which means either you're tired. Thank you very much. I feel better. It means that either you resumed listening or in fact, you got over your shyness. And so the proposal was that that reporting be handled by the multi-employer plan, and that isn't what the regulators came up with. They said, no, it would be easier if we just make you responsible. And you think, okay, fine, I can probably figure out when those folks are in fact full-time employees, but how the devil do I know when they have coverage? They might well have hours banks. They have to earn a certain number of hours in the 2 lagging months on average, and then they get coverage in the coming month. And I don't know whether they have coverage or not. I'm still paying every month because that's what I'm required to do. But whether they have coverage or not, yeah, that's your problem according to the way the rules are written right now. We might get some relief. We in this room are not the only people who are aware of this problem. But so far, the regulators are saying, no, that's your problem. So one of the things you'll see on the to-do list at the end is get hold of those multi-employer plans, and let's see if we're going to figure out how we're going to coordinate with them about that. That's a nasty surprise. Okay, now you're scared owls, but still wise owls, and wisely scared, I suppose. So what do we have to tell them? On the 1094-C, that's the transmittal form. The 4 is the transmittal, the C is the large employers. We're going to give them general contact information, whom to contact. And since that form is signed under penalties of perjury, you might want to think carefully of which of your colleagues is going to sign that. Maybe the person that you didn't like very much. Maybe that person that Dave Rewald has just told you how to fire. And if you're going to designate some other governmental agency, you do that right here on the 1094-C. So if, in my example, the fire department says, no, the city will take care of that. They're filing the form for our employees, even though we have a separate plan. Great. Then they're designated on that form. Part 2, we're still on the 4, which means the transmittal, and the C, which means the large employer. Part 2, you say which is the authoritative transmittal. So my example where payroll service X filed the form for the fire department, the city filed one other form, the city would probably check the box on line 19 to say, yes, this is the authoritative transmittal. The good news for you public sector employees is how you define your controlled group is pretty much up to you. The IRS said a few years ago, we don't know how the devil to figure out whether the city and a special district or something else is part of one or part of or separate. So whatever you say, if it's reasonable, is going to be fine with us. But for those of you poor private sector employers who came today, thank you for coming. This is a pain for you to identify your controlled group. And you'll have to identify all of the members of the controlled group ranked in terms of number of employees. That will be a small nuisance for you all. If you're requesting reporting relief, and I've bolded the one I think is relevant here, you would check that here on 1094-C. Basically, if you say, yeah, we're offering coverage to everybody. All of our full-time employees get affordable minimum value coverage, and so we just check the box. So we can report less than other people have to do. You can check a box. You still have to fill out the form here, the 4C, and also the 5C that we'll talk about, but there are some exemptions. The critical thing here is this is where you check the box if you're between 50 and 99. So I put you on the spot again. Anybody between 50 and 99 full-time equivalent employees? Yeah, good. So the good news is you know you're not subject to the shared responsibility penalties for 2015. You check the box. You still have to file the form, and please do check the box. This is how you tell the regulators, leave us alone this year. In the 4C, in Part 3, we basically say, are we offering minimum essential coverage to at least 95% of our full-time employees and their dependents? You can check a box to say, you can say yes, even if you miss 95% for this year and hit 70%. Remember, there's that special rule. You always check yes if you're between 50 and 99, again, because you're not subject to the rules for 2015. And if you have employees who are basically in a limited non-assessment period, which we'll talk about in a moment, you can just ignore them. You don't have to report about them. Column B, you say how many full-time employees we have and how many total employees we have in column C. You identify the controlled group, again, more of an issue for the private sector employees, and you say, are you eligible for transition relief? There are 2 points here. There's the big one. If you're between 50 and 99, you check that box. Again, that's how you tell the regulators, leave us alone for 2015 if you have a fiscal year plan, even a few months into 2016. Also, remember that you don't get penalized under the shared responsibility penalties for the first 30 of your full-time employees if, in fact, you've failed to provide coverage. But for this year, you get to subtract the first 80. If you're relying on that rule, if you say, yeah, we covered most, but we left out the first 80, you check the box here, again, to tell the regulators, I know that we didn't satisfy the 95% or even the 70% rule, but we get to subtract the first 80, and that results in no penalties. This is where you identify all the other members of the controlled group, especially for you private sector employers. Okay. I think this is how you're feeling. It's how you should be feeling. You're right to feel this way. I'm validating your feelings. Let's look at the 5C form. So we've passed the transmittal letter, and we're going over and looking at the actual reports, the reports that you're doing, basically one per employee. So a separate return, a separate Form 1095-C for each subject employee. That means all full-time employees, even those now who are in the non-assessment period. So maybe you've hired them, either they're in their initial measurement period, if they're variable hour, or in their first 3 months waiting period. You still file a report for them, even though you don't get a penalty if they're not getting or being offered coverage. Those are the full-time employees. If part-time employees are enrolled in your plan, so they're under 30 hours a week, under 130 hours a month, but you've offered them coverage anyway because you're more generous, you have to do a report for them too. Remember, that comes under Gary Bullard's familiar heading that no good deed goes unpunished. And then the last category is those enrolled non-employees if we're putting them on a C form instead of a B form. The independent contractors, if we're covering them, the outside directors, the former employees, the COBRA qualified beneficiaries. So those are the people who are included in this one person per report. And what are we reporting? So we're identifying the employer, and we're identifying the employee on whom we're reporting. We're saying whether we've offered minimum value coverage to that full-time employee and that person's family. We're saying what the cost of employee only, the cheapest employee only coverage available to that person was, so they can determine whether it was affordable and whether we're subject to a penalty and the employee is eligible for a subsidy. And then we have to justify why we shouldn't get hit with a shared responsibility or play or pay penalty. And here we do that with code. So we basically say, no, that person wasn't employed by us this month. Basically, it might be a COBRA qualified beneficiary and wasn't employed for any part of the month. It's not the month of termination. It's basically the month after termination and the months following. We say the person wasn't full-time and wasn't enrolled. So for this month, the person wasn't full-time and wasn't enrolled. Maybe for a prior month, they were full-time. Or we say don't hit us with a penalty because the person was actually enrolled in minimum essential coverage. Or the person was in a non-assessment period, which we'll look at next. Or we made a contribution to a multi-employer plan. Remember, you don't get hit with a penalty if you contributed right along, but you have to report on the person. That was the nuisance. We have to know whether they're full-time and whether they've got coverage. But we don't get hit with a penalty if we contributed to the plan for that month for them, even if they didn't get coverage. We used one of the affordability safe harbors. We said, yeah, we offered them coverage, and we didn't charge them more than 9.5% of their regular wage times 130 hours a month, or toward their actual wages. And so we used one of those safe harbors. Or we weren't subject to the rules yet because we had a fiscal year plan. Maybe the rules became applicable to us on July 1, and until July 1, we weren't subject to those, and so we're reporting for those months, January through June, and so we were entitled to that transition relief. Here's what those non-assessment periods that I mentioned, where you can use a code to say, no, you don't hit me with a penalty for Tom this month because one of these things. It was my first year as an employer, as an applicable large employer, and I got 3 months to get used to it, and it was those 3 months, January through March. The employee was in his or her first 3 months of employment and therefore didn't have to be covered. The employee was in his or her initial look-back measurement period, so it was a variable hour employee. We have a 6-month or 12-month measurement period. That employee was in that measurement period, and so we didn't know whether he or she would or wouldn't be full-time. Or the person has just changed status during that initial measurement period to full-time, and we needed 3 months basically to adjust from that person's variable hour status to full-time status, and that's a non-assessment period. So no penalty for us if any of these 4 items applies. We identify the individual that we're talking about, the employee, the former employee, that is the full-time employee or the enrolled part-time employee. And what happens? What happens if we don't do it? Well, it's basically $200 per person on whom we should have reported per year. So obviously that can add up fairly quickly. That can be a big number, and that's putting to one side any sort of fraud or other criminal type penalties. This is if we just don't do it. We don't understand it, or we do it wrong. So here's your to-do list. The to-do list says, remember the W-2 reporting. Remember I said the lucky person in this room who said, I'm not an applicable large employer and my plan's fully insured. You still have to do that W-2 reporting, and that's in Appendix A. Not going to go through any of those slides with you, but remember you have to put the cost of coverage and code DD, as in Dwight D. Eisenhower, on the W-2 saying what that person's coverage cost. Then you have to determine whether you're an applicable large employer for 2015. Think about whether your health plans are fully insured for 2015, because as you've seen, that affects what you have to report, if anything. If you're a small employer, it may be nothing. If you're fully insured, probably a good conversation to have with your insurer representative or broker about what they're filing. And if you're self-insured, you have to gather that relatively small amount of data about the people to whom you're offering coverage. That's on the B forms. If you're an applicable large employer, your to-do list is harder, and you expected that based on what we've already said. Are you going to designate another governmental unit to file the report? If you're dealing with multi-employer plans, remember that you're going to be contacting them so that you can work out some protocol by which they'll tell you who had coverage during what months of the year. They'll tell you to get lost, but it may help you to have had the conversation. They'll say, no, that's your problem. It's like the story about, you know, how many Teamsters it takes to screw in a light bulb, and the answer is 6. You got a problem with that? Decide whether you're going to file one report or whether there's going to be multiple ones, like my example of X payroll vendor sending in one report, and then the city sends in a different one. If you're, especially if you're a private sector employer, or if you're a public employer and you're part of a larger group, think about who's in your controlled group. Again, typically not an issue for public employers. If you're between 50 and 99, that would be a good thing to know, because remember, you're going to check those 2 boxes saying I'm between 50 and 99, no shared responsibility penalty for me in 2015, and if I have a fiscal year plan, possibly extending into 2016. And then identify those employees on whom we're going to file reports, the full-timers, the part-timers who are actually enrolled in a self-insured plan, and the enrolled non-employees. And then these codes that we all looked at, why shouldn't you be hit with a pay or pay penalty, are probably a good way to think about what your pay or play compliance is. What's my compliance plan? Who could trigger a penalty for me? Because I'm going to have to report on it. Basically, I'm ratting myself out to the IRS. That's the to-do list. And once you got through that, you just rest. It's all easy. As you'll see in your materials, there's the Appendix A, which talks about that fairly simple W-2 reporting. You've probably been doing it. It became effective in 2013. And so when you've done that for the last couple of years, you know you're fine. And so that you know that the IRS, even if you think of them a bear, just says thank you. Thanks.